Quorum being present, the Subcommittee on Health, Employment, Labor, and Pensions will come to order. Good afternoon. I'd like to welcome our guests and thank you all for joining us today to discuss the very important subject of tribal sovereignty. For our witnesses, I realize this issue is not only important, it's deeply personal, and I appreciate your being here to share your views and your experiences. I believe they will be valuable in our discussion of H.R. 511, the Tribal Labor Sovereignty Act of 2015. Upholding Native American rights of self-determination has long been a priority. As far back as the 1830s, when the governmental authority of the tribes was first challenged, our courts have held that the tribes possess a nationhood status and retain inherent powers of self-government, end quotes. For decades, policymakers have agreed on the importance of protecting these fundamental rights. We should never stand idly by while the sovereignty of Native Americans is threatened, and that's exactly why we're here today. A little more than 10 years ago, the National Labor Relations Board overturned long-standing precedent with the landmark San Manuel bingo and casino decision that began using a subjective test to determine when and where to exert its jurisdiction over Indian tribes. This action was met with significant opposition from the Native American community and considered by many to be an attack on tribal sovereignty. In fact, at a hearing of this subcommittee in 2012, Robert Porter, president of the Seneca Nation of Indians, called the move, quotes, unfounded, end quotes, and a violation of treaty rights. During the same hearing, I myself expressed concern with the board's policy and its flawed interpretation of the law. Unfortunately, the board has ignored these and similar concerns and continues to exert its authority over Indian tribes. To make matters worse, the NLRB's actions have had ramifications that extend beyond threatening tribal sovereignty. The subjective nature of the board's process for determining jurisdiction has also produced a mess, and that I think you can say with a legal confusion is an understatement. Years of litigation have produced inconsistent and misguided board decisions, compounding the uncertainty felt by Native American tribes and their businesses. To help address these concerns and preserve tribal sovereignty over labor policies, our colleague Todd Rokita introduced H.R. 511, the Tribal Labor Sovereignty Act. The bill would prevent the NLRB from asserting its jurisdiction over businesses owned by Native Americans on tribal lands, codifying a board standard that existed long before the San Manuel decision. In doing so, it would protect Native Americans from the NLRB interference and provide legal certainty to the nation's Indian tribes. It's a common-sense proposal that has attracted bipartisan support. Today, we will hear from tribal leaders who will share their experiences and discuss the importance of protecting their cherished sovereignty. I look forward to hearing the views on the reforms outlined in the bill. And with that, I will now recognize a senior Democratic member of the subcommittee from Colorado, Representative Jared Polis, for his opening remarks. Mr. Polis, you're recognized.
Well, thank you, Mr. Chairman. I want to begin by thanking the chairman for pursuing regular order with this legislation. I'm glad we're first having a hearing on this legislation in order to collect facts and get feedback from various perspectives. This really shows how this committee should work, and I'm glad for this opportunity to listen and ask questions on this important issue. And thank you to our terrific group of panelists for taking your time to give us your in-depth perspective. As all legislative hearings should, I believe this hearing needs to be about fact-finding. This bill highlights the inherent tension between two important principles that many of us hold dear: tribal sovereignty over Indian nations and workers' rights. I fully support the sovereignty of our Native American nations, and I know many of us place a great deal of importance on their right to self-governance, control, and independence. I also believe deeply in the right of workers to organize, including Native American workers, and the ability of workers to fight for a safe and fair working environment. All legislation and National Labor Relations Board decisions must balance these competing principles. They should try their best, as should we, to make them complementary rather than competitive. We should not favor one at the expense of another. Reconciling these two priorities may be difficult, but we as the committee have a responsibility to dig into how we can effectively and fairly reconcile the issues and ensure that we protect tribal sovereignty while also respecting workers' rights. And discussing the implications of this bill on these two issues is where we begin the process. We should investigate knowing that this issue is about more than tribal sovereignty. It's about more than gaming restrictions or the National Labor Relations Act. It's not only about a respect for tribal sovereignty, it's also about whether the majority cares about unions and the right of workers to form unions. And as we've discussed hundreds of times, unions are the key to shrinking the wage gap, raising up the middle class, and creating good-paying jobs. Under current law, tribes are subject to many federal employment laws, including the Fair Labor Standards Act, OSHA, ERISA, Family Medical Leave, Americans with Disabilities Act, which begs the question, if this conversation is not solely about the right to join a union, should we also be having a discussion around due process and federal exemptions for a variety of American workers, including those under the American with Disabilities Act, OSHA, ERISA, and others, or even laws that prevent the use of child labor. I'll also point out that I believe most of the companies operated by our Indian nations would not take advantage of workers. As is always the case, however, there can be bad actors and good actors, and in circumstances like these, we want to make sure that we don't overburden good actors, but at the same time, we want to make sure that workers, including Native American workers, cannot be taken advantage of by the rare bad actor. American tribal sovereignty is a core principle that I believe in. We also need to analyze the issue with the knowledge that many of these businesses and casinos are part of interstate commerce, and that there are many people who work at businesses owned and operated by Indian nations who may not be enrolled in the tribe that owns the casino. That means these individuals have no ability to raise the issue of workers' rights within the context of tribal law, so the question becomes, what laws protect them, and what rights do they have under American law? I'm very interested in hearing from our witnesses on both sides of the issue about how this affects sovereignty, local control, and the health and economic vitality of working families. Thank you very much, Mr. Chairman, and I yield back the balance of my time.
I thank the gentleman for yielding. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It is now my pleasure and privilege to introduce our distinguished panel of witnesses. Our first witness is Mr. Richard Guest, is a staff attorney with the Native American Rights Fund in Washington, D.C. Mr. Guest is the lead attorney for the NARF on the Tribal Supreme Court project, which is based on the principle that a coordinated and structured approach to tribal advocacy before the U.S. Supreme Court is necessary to preserve tribal sovereignty. Thank you and welcome for being here. It's now my privilege to introduce our second witness, but I'd like to recognize for that privilege Mr. Courtney, our colleague.
Thank you, Mr. Chairman, and it's a privilege to introduce my friend and neighbor, the chairman of the Mashantucket Pequot Tribal Council, Rodney Butler, who's here today to share his thoughts and perspectives on this issue. He is the leader of an extraordinary tribe in southeastern Connecticut, which has literally transformed the landscape in terms of the contribution that they've made to employment and economic growth in that area. And Chairman Butler has been chairman since 2010, a challenging time with a difficult economy, and has made great strides in terms of trying to achieve those goals. I worked with the tribe in terms of dealing with the leasehold term that BIA requires, and just a couple days ago he cut the ribbon for a new mall that's adjacent to the casino, 900 new jobs, and there's a job fair that took place a few days ago because they need more, and that's music to everybody's ears. He is, as I said, a native of southeastern Connecticut, graduated from Montville High School. He also graduated from the University of Connecticut. By the way, Mr. Chairman, did you know that the University of Connecticut women won the 10th national
I do not want to
championship?
talk about that this afternoon. being a UT alum.
He has an orange tie. I'll just stop right there in terms of mentioning that. And again, contributes greatly to nonprofits and charitable groups throughout the area. The nice thing about being in a democracy is that friends and neighbors can work together on many issues and sometimes agree to disagree on some. But I, again, look forward to hearing his testimony here today, and certainly welcome him to our committee. And I would yield back.
Thank the gentleman for yielding, Mr. Butler. Welcome. It's now my privilege to introduce one of our colleagues from California, Mike Thompson, to introduce our next panelist.
Thank you, Mr. Chairman. Thank you and Ranking Member Polis for organizing this very, very important hearing. and for your courtesy in allowing me to come down and join you at the dais today to introduce a constituent of mine, Mr. Gary Navaro, who lives in my congressional district in Santa Rosa, California. He's an enrolled member of the Pomo tribe from the Round Valley Reservation, and he's an employee at the Grayton Casino and Resort in Rohnert Park, also in my congressional district. Mr. Navaro can speak firsthand on the important work unions are doing on behalf of workers employed in tribal casinos. He was part of the organizing effort at the Grayton Casino and serves on the bargaining committee for Unite Here Local 2850. He was also elected from Sonoma County as a senior chair to the California Rural Indian Health Board and serves as a Santa Rosa Little League Baseball board member. Accompanying Mr. Navaro are workers employed at tribally run casinos in California, including Thunder Valley, Cache Creek, San Pablo, and Grayton Rancheria. The questions that you're going to be dealing with today is extremely important, and I'm very happy that you're taking this up, and I know that Mr. Navaro will add much to your debate and to your hearing. So thank you, Mr. Chairman. And I'd also like to thank one of your other witnesses, Lieutenant Governor Keel, for his service to our country as a fellow Vietnam veteran. Thank you, and welcome home.
Mr. Navaro, welcome today. And it's my privilege now to introduce our last witness, the Honorable Jefferson Keel. Is a Lieutenant Governor of the Chickasaw Nation. Mr. Keel is a retired U.S. Army officer with over 20 years active duty. His combat experience included 3 years of service in Vietnam as an infantryman, where he received the Bronze Star with V for Valor, 2 Purple Hearts, and numerous other awards and decorations for heroism. He has management experience in the private sector and tribal programs and operations. And as a fellow veteran, welcome home, and thank you for your service. I'll now ask our witnesses to stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect that witnesses answered in the affirmative, and you may take your seats. And thank you, gentlemen. Before I recognize your testimony, let me briefly explain our lighting system. You will have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time has expired, the light will turn red. And we do have votes, so I'm going to be pretty precise on the 5 minutes. We have votes later today, and I want to make sure we make those. At that time, I will ask that you wrap up your remarks as best you are able. Members will each have 5 minutes for questions. I would now like to, Mr. Guest, you are recognized for 5 minutes.
Thank you, Chairman Rowe, Member Paulus, Ranking Member Paulus, and distinguished members of the subcommittee. The Native American Rights Fund, NARF, is honored to provide this testimony, the purpose of which is to demonstrate that in furtherance of longstanding policies of Indian self-determination, tribal self-governance, and tribal economic self-sufficiency, it is time for this Congress to provide both clarity and parity for tribal governments under the National Labor Relations Act, the NLRA. For the record, NARF fully supports H.R. 511 as well as its companion bill in the U.S. Senate, S-248. As you are well aware, the NLRA was enacted by Congress in 1935 to govern labor relations in the private commercial sector. Under Section 2 of the NLRA, the term an employer is defined to include any person acting as an agent of an employer directly or indirectly, but shall not include the United States or any state or political subdivision thereof. Therefore, workers in the public sector, employees of federal, state, and local governments, were not afforded the rights and protections of the NLRA. Based on sound policy determinations, Congress provided those governments an opportunity to choose how best to regulate union organizing, collective bargaining, and labor relations with their workers, given the essential and oftentimes sensitive nature of their employment. So in this context, for tribal governments, parity encompasses the quality of being treated equally under the law alongside federal, state, and local governments. Tribal governments are entitled to the same freedom to choose for themselves the appropriate time, place, and manner for regulating union activity on Indian lands and collective bargaining for their employees. H.R. 511 provides the necessary clarity and certainty, recognizing that those sound policy determinations apply with equal force to tribal governments. In terms of parity with the federal government, It was not until 1978, 43 years after it passed the NLRA, that Congress enacted the Federal Labor Relations Act to regulate labor relations with federal workers. To meet the special requirements and needs of the federal government, Congress chose to exclude employees of certain federal agencies, limited collective bargaining with no right to negotiate wages, hours, or employee benefits, and eliminated the right to strike of federal workers. In terms of parity with state and local governments, according to the 2002 GAO report, only 26 states and the District of Columbia had statutorily protected collective bargaining rights for their employees. 12 states had allowed collective bargaining only for specific groups of workers, such as teachers and firefighters, and 12 states did not have any laws protecting the rights of its employees to collectively bargain. According to the GAO report, most state government workers are entitled to collective bargaining rights under state law are all prohibited from striking. Instead, those states provide compulsory binding interest arbitration, a procedure not available under the NLRA. Mr. Chairman, we hope that you and each member of the committee will recognize that each of the 566 federally recognized tribes as governments must have the opportunity to make their own policy judgments regarding labor relations on their reservations, based on the values and priorities which best serve the needs of their community. In general, there are 4 areas of concern for Indian tribes. 1, a guaranteed right to strike threatens government revenues and the ability of tribes to deliver vital services. 2, the broad scope of collective bargaining will undermine federal and tribal policies requiring Indian preference in employment. 3, preemption of the tribal power to exclude diminishes the ability of tribes to place conditions on entry, on continued presence, and on reservation conduct. And 4, the potential for substantial outside interference with tribal politics and elections. Although there are several examples to choose from in my testimony, I provide summary of the Navajo Preference and Employment Act of 1985 and include as an attachment to my written testimony the collective bargaining regulations promulgated by the Office of Navajo Labor Relations. It was a legislative intent of the Navajo Nation Council to incorporate the most basic protections of the NLRA to tribal employees whom the council acknowledged were otherwise exempt from the NLRA. Included as attachment C is the Model Tribal Labor Relations Ordinance, the result of the great experiment with the tribes and the state of California in their gaming compacts, resulting in labor relations being granted in that state. So in closing, today, as a result of the success of Indian gaming and the San Manuel decision, the NLRB no longer draws a distinction from whether the tribal business was located on or off reservation, but rather what it determines to be commercial activities of an Indian tribe versus what it deems to be traditional governmental functions. I see my time has expired, so I'll end my testimony there. Willing to take questions. Thank you.
Thank you, Mr. Guest. Mr. Butler, you're recognized for 5 minutes.
Thank you. Good afternoon, Chairman Rowe, Ranking Member Polis, my good friend Joe Courtney, and distinguished members of the committee. I am Rodney Butler, the chairman of the Mashantucket Pequot Tribal Nation in Connecticut. I want to thank you for inviting me to testify in support of the Tribal Labor Sovereignty Act because it's critically important to protect the sovereign rights of tribal governments. First, I would like to thank Congressman Rokita for introducing this legislation and the nearly 50 bipartisan co-sponsors of this legislation. Indian country has always received bipartisan support in Congress, and I hope this bill will continue in that tradition. H.R. 511, the Tribal Labor Sovereignty Act, is a very straightforward bill. The legislation expressly confirms that Indian tribes are on equal footing with state and local governments under the National Labor Relations Act. That is all that it does. It reaffirms the fact that tribes are sovereign governments and should be treated that way under all federal laws. The issue of tribal government parity has been a priority in Indian country for decades. We have successfully worked with Congress to reaffirm our tribal sovereignty under the Violence Against Women Act, federal unemployment taxation, general welfare tax issues, and a host of other laws. Today, we continue to fight for tribal parity on issues relating to municipal bonds, pensions, the bankruptcy code, and the NLRA. I am pleased that all of these efforts have been supported in Congress, again, by a bipartisan basis. However, I'm concerned today that some people have tried to portray this legislation as being anti-union, and I wholeheartedly disagree with that assessment. I would like to share with the committee our experience with organized labor at our Foxwoods gaming facility. In 2007, the United Auto Workers filed a petition with the NLRB to organize the dealers at Foxwoods. Applying its wrongly decided San Manuel standards, the NLRB asserted jurisdiction over the Mashantucket Pequot Tribal Nation and our Foxwoods Casino. At that point, our tribal council had to make a decision. Pursue this issue in the courts, which would have led to years of distracting and hurtful litigation, or work with the UAW to help them understand how they could organize and protect collective employee rights under our tribal labor laws. Our government decided to reach out to the UAW, explain that this was an issue of tribal sovereignty, and encourage the use of tribal law to reach a solution that respected both tribal sovereignty and workers' rights to organize. These discussions gave the tribal nation an opportunity to educate the UAW regarding the importance of tribal sovereignty, the importance of tribal culture and tradition, and the significant tribal laws and institutions that were in place. At the same time, it gave the UAW an opportunity to educate the tribal nation on the importance to the union of protecting employee rights to organize and the UAW's efforts and successes over the years protecting those rights. Both the UAW and the tribal nation were open to listening and learning from each other. Over a period of time, we reached an agreement with the UAW to pursue collective bargaining under tribal law and entered into a collective bargaining agreement with the UAW. I think both the tribe and the UAW believe this agreement has worked well for both sides. In fact, today, 3 additional unions represent our government employees at Mashantucket. They include the International Union of Operating Engineers, the International Association of Firefighters, and United Food and Commercial Workers. All of these unions have collective bargaining agreements with our tribe. The San Manuel decision was not only a complete reversal of the NLRB's recognition of tribes as sovereigns, it is also an affront to Indian country. It suggests that Indian tribes are incapable of developing laws and institutions to protect the rights of employees who work on our reservations. Our experience proves nothing could be further from the truth. The Mashantucket Pequot Labor Relations Law protects the rights of employees to organize, to vote to select union representation in secret ballot election, and to bargain collectively with their employer. Elections are conducted and the law is enforced by the Mashantucket Employment Rights Office, a separate government agency headed up by a labor lawyer with over 25 years of experience, including 8 as a field examiner and attorney for the National Labor Relations Board. Similar to other public sector labor relations laws, our labor law requires the parties to negotiate in good faith, and when negotiations fail to result in a contract, the dispute may be submitted to a binding interest arbitration. The law provides for a dispute resolution by a 3-member panel selected by the parties. All of these developments have been praised by unions, labor lawyers, and even former NLRB officials alike. In addition to our labor law, the tribal nation has enacted legislation allowing employees the right to challenge terminations from employment and suspensions of 5 days or more. We adopted ERISA as tribal law. We've created remedies for denial of health benefits and a tribal civil rights code allowing employment discrimination claims. Our tribe made the sovereign decision to permit collective bargaining with unions when designated by a majority of the employees under our laws. It should be the right of any sovereign government to make decisions that are best for their people. H.R. 511 simply allows tribal governments to make those decisions. Section 2 of the NLRA expressly excludes the United States government and state and local governments from the Act's jurisdiction, and that makes sense. Sovereign bodies have unique employment concerns, and the sovereign is best suited to address those concerns. We seek to be treated just like every other sovereign under the NLRA, nothing more, nothing less. That is why this legislation enjoys wide support in Indian country, the National Congress of American Indians, and organizations that represent all Indian tribes in the United States unanimously adopted a resolution supporting this legislation. In fact, we have not heard from any tribe opposing this bill. With over 560 federally recognized Indian tribes, it is truly remarkable to have such unanimity in Indian country. Mr. Chairman, the Tribal Labor Sovereignty Act simply reaffirms our sovereign rights, and we urge the committee to pass this legislation and move quickly to get the law enacted. Thank you.
Thank you, Mr. Butler, for your testimony. Mr. Navaro, you're recognized for 5 minutes.
Congressman Rowe, Ranking Member Paulus, and the members of subcommittee, thank you for inviting me to testify today. My name is Gary Navaro. I'm from Santa Rosa, California. I'm an enrolled member of the Pomo Nation and a worker at Grayton Casino and Resort in Northern California. While I'm appearing here today as a Democrat witness, I am registered as a Republican. As a Native American, I am strongly opposed to the idea that the name of my heritage, one of my most important rights Americans have, namely the right to form a union and collectively bargain, would be taken away from thousands of people like me who work in a Native business. I become active in my union because of adjusting treatment of casino workers by the managers and how nothing could be done about even sexual harassment because of sovereignty. Exercising our rights to organize turned out to be the only way to protect ourselves and our coworkers Please do not strip us of these rights. My grandmother and her children grew up on the Round Valley Reservation in Covelo, California. My family has lived there many generations. People there were poor. They do not have an education. There is much crime there because of a lot of alcohol and drug abuse leading to violent crimes. My grandmother left the reservation at a very young age to bring her family to Santa Rosa because she didn't want them to deal with the same life of poverty. My whole life, my grandma has taught us to hold our own and stand up for what is right. As I grow up, she always would teach us heritage and to be proud of who we are, but also to be hardworking and understanding towards others. Today, I'm a slot attendant at Grayton Casino. In total, there are about 2,500 employees at the casino, but only 5 are Native Americans, and 1 of them from the Grayton Rancheria. No managers are Native. The casino is managed by Stations Casinos on behalf of the tribe. I have seen sexual harassment at the casino. As a general manager going up to women, telling them that if they want promotions, they had to sleep with him. The women were fired. We all complained. Managers at Station Casinos told us it was a sovereign nation. It was bad enough that Title VII of the Civil Rights Act doesn't apply to Native businesses. Congress should not make the situation worse by taking away protections under the National Labor Relations Act. The NLRA enables workers who have been subjected to harassment and other forms of discrimination to get together and complain about it. Take away the NLRA, you don't only have sexual harassment, but no ability to speak about it. I was also part of organizing effort to help the collective bargaining at Grayton. I have never been in a union before, but we needed the union to help us organize ourselves so we could speak up about abuses without having to worry about our jobs being taken away from us. Even though Stations Casinos management was opposed to having a union, the Grayton tribal leadership went in and told them to back off. The union is recognized now, and we are at the end of our negotiations for the first contract right now. The union and tribe worked together to help the tribe pass their compact in Sacramento. I cannot sit back and watch and see legislation that would take the rights to organize and collective bargaining away from every worker at tribal enterprises in the name of Native heritage. It is especially troubling when I have family members who were all in the major wars, World War I and II, the Korean War, the Vietnam War, and I had relatives who died in that war. Spilling blood for an American flag has always been something my family has been proud of. My family died for these rights and for everyone to have, not just for Native Americans to have, but for races to have. These are rights that they believed everyone should have. Even though casinos are on piece of Native American land, it is still America. It's embarrassing as a Native American to think that this legislation could pass and my coworkers have no rights because my band of brothers, my family, my heritage took away thinking it was okay when it's not. I would be pleased to answer any questions you have.
Thank you, Mr. Navaro, for your testimony. Now, Lieutenant Governor, Mr. Keel, you're recognized for 5 minutes.
Chairman and members of the committee, thank you for honoring me with
Check your mic and see if it's on.
Is it on? Thank you, Mr. Chairman, and other members for the opportunity to speak for you today. To us, today's discussion is solely about sovereignty. It's about our government's government relationship with the United States, and it's about the federal government living up to the principles that have shaped successful self-determination policies for the past 40 years. All governments must be afforded the respect all governments are due. We accordingly call on Congress to correct misunderstandings that arise from the NLRA's not expressly including tribal governments in its list of those that are already exempt from the NLRA. As recognized since the earliest days of this republic, the Chickasaw Nation is a sovereign government. Acting under our Constitution and laws, our leaders provide citizens with a broad range of government services, including health care, housing, and education. And our government's direct operation of economic development initiatives and the revenues we raise from them are critical to those programs. Fundamental principles of federal law provide that American Indian tribal governments should be treated as other governments are under federal law, including treatment with respect to the right to government employee labor relations. When Congress enacted the National Labor Relations Act, or the Act, in 1934, it expressly exempted government employers. For 7 decades, the National Labor Relations Board, or the Board, properly construed the Act as exempting the American Indian tribal governments. In 2004, however, the Board moved away from that settled practice and began to assert jurisdiction over tribal governments based on a case-by-case determination that focused not on the sovereign status of tribal governments, but on an inquiry as to whether the tribal government's actions were sufficiently governmental in nature. This is an inquiry for which the Act or no common law provide any meaningful criteria, which is applied to no other government. The board applies this test to not federal, not state, not municipal, only tribal. In 2011, it was alleged that the Chickasaw Nation violated the NLRA at our WinStar World Casino. We contested those charges, asserting both our fundamental status as sovereign nations and our treaties with the United States. Earlier this month, we won a ruling from the board that recognized our treaties as barring NLRA jurisdiction over our workplaces. Our win is a long overdue victory for sovereignty, but it remains incomplete. First, it rests on treaty provisions that are unique to us and our sister sovereign, the Choctaw Nation of Oklahoma. Instead of relying on broader federal law principles, the board appears to instead have found the narrowest path possible for coming to the right conclusion. Second, the test that the board applied is only 10 years old. More to the point, that test reversed 70 years of the board's prior understanding of the law. What assurances do we have today that the board will stay with this understanding? The governments of Indian country deserve stability and certainty under federal law. Tribes have demonstrated their ability, as you've heard, to address these issues on their own. For example, tribal governments in California have negotiated compacts that address tribal workplace unionization. That may have been a sound decision by those tribal sovereigns. It may not be one that all tribal governments or even state governments might make. Certainly is not a decision that the board should make for tribal governments. Franklin Roosevelt himself argued for not subjecting governments to the NLRA, which he emphasized was developed for purposes of regulating private enterprise labor relations. His caution was well-founded and should apply with respect to all governments, including tribal governments and their sovereign rights to regulate their own government labor relations. The Tribal Labor Sovereignty Act would provide Indian country with the stability and certainty it deserves, and the Chickasaw Nation accordingly calls on Congress to correct its prior error by adding tribal governments to the list of those already exempt from the NLRA. Thank you again for inviting me to appear. I urge you to do everything you can to ensure swift passage of the Tribal Law Sovereignty Act. Thank you.
Thank you, Lieutenant Governor, and again, thank you for your service to our country. I'm going to yield myself 5 minutes and get started, and really I think this is about as clear an issue as I've ever seen. And I'm amazed that you can get 566 Indian tribes. I was at a doctor's meeting this morning with 13 of us, and we couldn't agree on anything. So I'm astonished that you have that. And if you watch the Congress operate, we'll never agree on 100%. So it's pretty amazing. Look, I think this is fairly simple. Let me just show you how I see it. One is either you're sovereign or you're not. You can make your decisions or you cannot. The NLRA, and I want to read this, the NLRA does not cover all employees and employers in the United States. For example, public sector employers, that's the state, local, and federal governments, employers covered by the Railway Labor Act, that's airlines and railroads, agriculture labor, and supervisors are not covered under the Act, 29 United States Code. So it's clearly, you're correct, Mr. Keel, you made the point that it was just left out, and then it left 70 years of basically what we thought was law, changed in 2004. So I see this as very, very clearly. We should clear it up with one small bill. It's a very simple bill, and it would then allow you to make those decisions. I am for making those on a local basis. And I think Mr. Butler made a great point in his testimony, and I'll turn it over to you. This is not anti-union. If you want to unionize where you are, that's perfectly okay to do. And people have, clearly, and you've worked with the unions. I've said this since I've been on this committee. And the time I've been in Congress, it's a right in this country. If you want to do it, you can. If you're fully informed, you want to vote for a union, you can do that. I grew up in a union household. I absolutely understand how that works. But you also have a right not to unionize if you don't want to. And I think your point was well taken, Mr. Butler. If you'd like to comment on that, I'd like to hear your.
First, my condolences to UT. I apologize for being a Husky, so. But no, absolutely. I mean, look, we have a tremendous relationship with our unions. I mean, we work hand in hand on many things. In fact, we just worked on an expansion of gaming bill in the state of Connecticut that was, in concert with union support. And so, I mean, those are union jobs that are going to get impacted, and we realize that because of the way that we care about our employees, we work with them together to get that legislation passed. And so, we work together throughout the community, and charitable organizations, and it's been a very successful partnership, again, that we chose to enter into.
And I think, Mr. Keel, I want you to comment. I think you made a point a minute ago about, at least the way I understand the NLRB made this ruling, was that if you're using the profits, some of the profits of your casinos for services in the tribe, am I correct on that?
That's correct. Yes, sir.
And when you do that, that would seem to me like if you are a sovereign nation, you need those revenues to be able to provide the services that your constituents expect from you. Am I correct?
That is correct. Yes, sir.
And have I missed the point at all in this? It's a fairly simple, straightforward. I don't see how there could be much discussion. Either we have, in these treaties that we did with 566 tribes in this country, have allowed you to be a sovereign nation, or we have not. And I think we have. Any comments? Mr. Guest, you've...
I'm sorry, Mr. Chairman.
I said the point is what we've done is that in this country, we've either said through these treaties that we've had with the nations, the Native American nations, that you're a sovereign piece of property or you're not. And I think clearly you are and are able to make your own decisions. Am I interpreting that wrong?
No, sir. I mean, that is exactly the point that tribal leaders are bringing to you today, is that they are no different than states, than the United States. The challenge is that Congress was silent with respect to the language in the NLRA, and due to that silence, it's created the opportunity for a lot of confusion in this area of the law.
Okay. Mr. Polis, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mike, first question for Mr. Guest, and what is the implication of this bill, if passed, on the applicability or the precedent that's set with regard to the applicability of American with Disabilities Act, OSHA, FLSA?
Well, this H.R. 511 only addresses Congress's silence in the NLRA in including tribes in the exemption to the definition of employer, along with state, local governments, and the federal government. It doesn't have any impact on any other federal law.
So how does one differentiate, for instance, among the right of those with disabilities to have reasonable accommodations at work versus the right of workers to organize? I mean, why this particular set of rights as opposed to some of the other national protections that exist even in tribal nations?
If my recollection serves me, Indian tribes are exempted from the definition of employer in the American with Disabilities Act. However, in other employment legislation, Congress, again, has been silent with respect to Indian tribes. The courts have interpreted that silence to create the rule regarding laws of general application apply to Indian tribes in the employment context, saying that those laws like FLSA, OSHA do apply.
And in your opinion, should those laws not apply to our sovereign nations, OSHA and FLSA?
Well, I think the difference here is that with respect to the NLRA and its impact on tribal sovereignty is vastly different than the impact with respect to OSHA or Federal Labor Standards Act. It really is about safety and health regulations, wages and overtime, which is a very different a set of rules versus union organizing on the reservations. Inviting third parties to come onto the reservation and the tribes having no ability, no authority to regulate their presence.
Reclaiming my time. Mr. Navaro, you as a general principle, do you support our sovereignty of our Native American nations?
Yeah, I support sovereignty.
And how would you view that this bill would impact both workers' rights, and how do you reconcile your support and the support of many of us of Native American sovereignty with your support of workers' rights?
The workers' rights, they're just given rights that people have. You can't really go and take them away and say this is a sovereign nation. This is America. Honestly, it's America. You can't just say, I'm taking your rights today because it's a sovereign nation. You can't use that against people. Those are hardworking Americans who are busting their butts in their workplace for these tribes, and to come in and just say, we're going to use sovereignty against you to take rights away isn't fair to them.
Mr. Butler, there's, with regard to employees of Native American nations, enterprises that are not affiliated with the tribe, either members of other tribes or a non-Native American, they clearly don't have a say in tribal governance. And my question is there any mechanism under this bill where non-tribal employees could somehow influence the process around the conditions of their employment if they're not enrolled members of the tribe?
If they're not enrolled members of the tribe? So we treat all of our
About
employees.
75%, I think, of the employees, I understand, of
Yeah.
across the industry are not
Right.
members
I mean,
of the tribe.
we have non-native employees. We have native employees who aren't enrolled members of our tribe as well, and we treat them all the same, right? And so, and again, we've chosen, as Richard spoke to the other laws that don't necessarily apply to any country, you know, that's our sovereign right to accept those and apply those, and we've chosen to do so. And in this case, again, we've put in place our own labor law. We have a disability law. We have a civil rights code, and so those all on our sovereign actions have been applied to all of our employees.
And if you were, if it was a tribe that didn't have those protections, would you then argue that those protections simply shouldn't be afforded to the employees, or should there be some federal or national backstop on that?
Well, again, in our case, as an independent sovereign, just as each state is independent, we've chosen to afford those opportunities to our employees. Now, same thing with states. Not every state has afforded those opportunities as well under the NLRA, but we have, and so we look at it in the same fashion.
Yield back to balance of my time.
Thank you.
I thank the gentleman for yielding. Dr. Fox, you recognized for 5 minutes.
Thank you, Mr. Chairman, and I thank our guests for being here today. Mr. Guest, just last week in NLRB versus Little River Band of Ottawa Indian Tribal Government, a divided U.S. Court of Appeals for the Sixth Circuit ruled the NLRB may apply the NLRA to a Michigan casino run by the Little River Band of Ottawa Indians on tribal land. How does the treaty with the Little River Band of Ottawa Indians differ from the Chickasaw Treaty?
Well, in the Little River Band case, they did not make the treaty argument directly, although they have a treaty with the United States. And the language in their treaty and the language in the Saginaw Chippewa, which is the next case up in front of the Sixth Circuit Court of Appeals, the distinction is that there's much more general language. They don't have the same language as in the Chickasaw Treaty that basically precludes any laws enacted by Congress unless it's made specific to the tribe. I mean, it's very narrow language for the Chickasaws and the Choctaws that the board recognized. And it's, the impact is going to be felt because not all federally recognized Indian tribes have treaties with the United States. Indian tribes entered into relationships with the United States in a variety of ways. And so not every tribe is going to have the benefit. Even those with treaties, as my friend Jefferson Keel indicated, have that good of language. It's just the exception, not the rule.
Thank you. Let me follow up, if I could. If the NLRB determines it as jurisdiction over an Indian tribe, then what will become of the tribal labor laws?
Well, that's a good question, and in the San Manuel case, it came up as well initially with the Model Tribal Labor Relations Ordinance in California, now with the assertion of jurisdiction by the NLRB in Little River Band. There are existing tribal laws, and what the NLRB has said is, well, those that conflict with the NLRA are no longer applicable. So now there's going to be litigation over, well, what conflicts with the NLRA and what doesn't, creating more litigation, more uncertainty. The decision by the NLRB in Chickasaw and the decision by the Sixth Circuit in the Little River Band case, again, illustrate for us why Congress needs to act, and act quickly, with respect to H.R. 511.
Thank you. Lieutenant Governor Keel, The NLRA includes the right to strike. Would a strike at your casino affect government operations in the Chickasaw Nation?
Absolutely. I would liken it to what happened with the air traffic controller strike a number of years ago to this country, where a group of individuals basically crippled the transportation system of this whole country. We obviously are not as large on a larger scale, but that's the type of activity that would interfere with what we're doing. We depend on the revenues to make sure that we provide services, whether it be housing, health care, emergency assistance to our citizens, and we could not stand for that.
Thank you. Let me go to one more question. I believe I have time. In July 2013, a board panel concluded that it had jurisdiction over the Chickasaw Nation. Can you tell us what was the basis for that holding, and have the treaties between the Chickasaw Nation and the United States changed since 2013?
No, ma'am, they have not changed. The treaties have not changed and will not change. But thank you for that question. The specific language that applies to the Chickasaw is that no laws, as Mr. Guest has stated, would ever be passed that would be contrary to the Chickasaw Nation, or unless it was passed specifically for and to the Chickasaw Nation.
Thank you, Mr. Chairman. I yield back.
Thank you, Gentlelady, for yielding. I now recognize our ranking member, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Lieutenant Governor Keel, apparently some federal laws apply to tribal activities and some don't. If you believe in sovereignty, why shouldn't they all apply or none of them apply?
Thank you. The Chickasaw Nation, we have adopted laws, ordinances, and employee relations that cover all of our employees. We treat, as you've heard, all of our employees the same. We go through a process every year of a master planning session where we sit down and we look at what our needs of our employees are. As for in terms of benefits,
we're talking about in this hearing. We're just talking about NLRB. What about other laws of general application? Why shouldn't they all apply on tribal lands, or none of them apply? How do you tell what applies and what doesn't?
Well, the laws that the federal laws that we operate under, many of our programs are federally funded, so we operate by those rules. Many of the benefits that are afforded to our citizens are the derivative of that. The Fair Labor Standards Act that we operate under those rules and regulations and those laws.
Should you have to?
We don't feel that we should have to, but we do.
So I guess the question again is, why should some apply and some not? What would happen if the business involved hires the vast majority of employees are not Indians? Should the NLRB apply to that kind of business?
If it is a tribal business operated by the tribal government, by the Chickasaw Nation, the answer is no. The NLRB should not be. We are capable of developing our own laws and rules and regulations that would far exceed those needs. In fact, our employees are the wages of our employees meet or exceed any of the standards. The benefits of our employees are better. They have better health care, better benefit packages than anywhere around. So we don't feel that the NLRB has any state at all in our affairs.
What about other laws? OSHA, should that apply? Occupational Safety and Health Act?
Again, sir, as many of our programs that we operate are covered under those federal laws, we operate under those rules, and we do make sure that we're within the law.
Why should you have to operate under that and not NLRB law?
As I've said, sir, I believe that we're capable of developing our own rules and laws, or tribal law ordinances that would actually improve on those conditions.
The discussion involves businesses on Indian land. There have been occasional land swaps where you take some Indian land and trade it with some downtown land so that the hotel is actually on Indian-owned land. Should these exemptions apply to a downtown casino?
Once again, the Chickasaw Nation is a sovereign nation, and we operate our businesses as a sovereign nation, so our laws apply to all of our businesses regardless of where they're located, as long as they are within the on trust lands, as you would refer to.
Well, I mean, if you swapped land and had trust land and really downtown and had a downtown casino, should that be considered exempt from the various laws that we're talking about?
So there's a process by which the lands are taken into trust that we go through a lengthy process to determine whether or not these lands are placed into trust. Once that process is completed, then yes, we operate those businesses just as any of the other business we operate as a sovereign nation.
And you would expect to be exempt from the NLRB in that situation where you have what is essentially a downtown casino that you own?
If it's on our lands, yes, sir.
Thank you, Mr. Chairman.
I thank the gentleman for yielding. Mr. Salmon, you're recognized for 5 minutes.
Thank you. Mr. Guest, my first question is going to be for you. Is it your understanding that state and federal governments, that their employees have to operate under OSHA?
I'm not an employment or a labor law attorney.
My understanding is that they are. In fact, if anybody can dispute that, in fact, the ADOT folks, as they're building highways, they have to comply with OSHA regulations. And so this isn't really about whether or not you guys want to pick and choose the laws. You want to be treated like the same or the same as the other carve-outs, whether it's the federal government, the state governments. In fact, you mentioned in your testimony that Section 2 of the NLRA states that the term employer is defined to include any person acting as an agent of an employer directly or indirectly, but shall not include the United States or any wholly owned government corporation or any Federal Reserve Bank, any state or political subdivision thereof. And so they're okay with not having those guys comply with the NLRB rules and regulations, but they've kind of singled you out. I hear some of the argument on the other side saying that, you know, asking if you should be exempt from OSHA. Well, the states aren't exempt from OSHA. The federal government's not exempt from OSHA. And so all you're asking for is to stop being treated like some second-class government entity. Isn't that what we're saying?
Well, I think that you have brought an argument to the table that we have not directly thought of, Mr. Salmon. I think that that's exactly right, is that the fact that federal and state employees or governments are not exempted from OSHA, from Federal Labor Standards Act, and others, again, brings the parity issue right back into focus, that tribes should not be second-class governments. And again, the difference between those laws and the NLRA is the fact that over the course of time, tribes are working directly with folks at Department of Labor who enforce the employment laws. They're dealing directly with OSHA and enacting statutes that reflect OSHA, that, as Mr. Butler said, they have enacted ERISA. They've adopted ERISA as tribal law. That's the act of a sovereign, that they're enacting their own laws, some tribes actually increasing the protections for their workers over and above what the federal minimal requirements are. So again, it's allowing tribes to act in that sovereign capacity.
I guess I just resent you being singled out as the one government entity that has to either, you know, has to accept this, or somehow you're not caring about the tribal members that you have purview over. I don't buy that. In fact, I think that I think this is very, very consistent with the other laws that are on the books, and that, you know, these other government entities are exempted. Then if they're exempted, you should be exempted. That, to me, is pretty cut and dry in the way it ought to be. Lieutenant Governor Keel, in your testimony, you did an excellent job emphasizing the basis for and the importance of tribal sovereignty. And I'm a proud co-sponsor of the bill for the reasons you stated.
Thank you.
Todd Rokita is a great American, so thanks for introducing this bill. Do you anticipate much opposition to the bill? If so, what interests do you believe are going to be interested in restricting the rights of sovereign tribes to handle their own affairs in this area?
Thank you, Mr. Chairman, and thank you for being co-sponsor for the bill. I'm not sure of the opposition. I'm not sure what level of opposition we would receive. I'm not sure why they would oppose tribal governments being treated as every other government in this country, as it's recognized. Our inherent sovereignty is recognized in the Constitution of the United States in Article 1. I'm not sure why there would be any opposition to this. This simply clarifies misunderstandings that have arisen with the NLRB over the past 70 years. So,
well, if the NLRB is going to be consistent, then it ought to go after the state and the federal governments as well, if it's going to be consistent. All we're asking for is to quit having this darn double standard. Isn't that
yes,
right?
Sir. Yes, sir. Absolutely.
Okay, I yield back
Thank you.
the balance of my time.
Thank you, gentlemen, for yielding. Mr. Pocan, you're recognized for 5 minutes.
Sure. Thank you, Mr. Chairman, and thank you to our witnesses. Let me try to follow up on Mr. Salmon and Mr. Polis's question, and even the chairman when he said you're either sovereign or you're not. And as I hear some of this discussion, it sounds like there's more than one inconsistency with how law is applied. And Mr. Guest, I think specifically the questions that were asked by Mr. Salmon and Mr. Polis. So it sounds like it's not just this one law where you're treated differently, but it sounds like there's other labor, consumer protection, and environmental laws that are treated differently. So if I understand right, the Fair Labor Standards Act has been applied to tribes, correct?
Correct.
And I believe OSHA we were talking about has been applied to tribes?
Correct.
Okay. ERISA, the federal pension law?
Correct.
Age Discrimination and Employment Act?
I believe there's an exemption for tribes. Not under the age discrimination, I'm talking American with Disabilities.
Yeah, not the ADA, but specifically that.
Correct.
So I guess when I look at that, and when we asked before about that, we said, well, courts have made this determination. So I guess my question is, are you looking for a legislative fix to all of these areas? Because clearly, if you're either sovereign or you're not, is the argument, then there's some other things that need fixing. So are you looking for a legislative fix across the board on these issues?
I don't believe so. I think that what we're looking for is exactly what the testimony is about parity with respect to the way in which Congress is treating tribes with respect to labor relations. It allows state governments and state governments, local governments, and the federal government to enact their own labor relations laws for their employees, but does not allow tribal governments to do that.
But if I understand it right, local governments aren't under some of the same things that you are under in some of these other laws. So, I mean, if you really want the parity, shouldn't we address each of these areas, or are we just going after labor unions as an issue? I mean, that's why I'm just trying to understand, because if there's the consistency, I think it would be all these areas.
I think it's a policy decision that is considered by tribal leaders with respect to where the challenges are. As a result of treaty making, Indian tribes ceded much of the land in this country over to the United States, and also ceded much of their authority outside of their own lands. And as a result, they have this unique relationship with the United States. It's the same principle that applies under federalism with the state governments and the United States government. You know, that certain powers were ceded to the central government, and those retained by the state.
But perhaps I'm misunderstanding it, but wouldn't all of these issues that I mentioned that you said apply to you that aren't applying to local units of government, wouldn't that also be then something that needs to be fixed? I mean, it seems like we're picking one little area, but it sounds like we found about 5 or 6 areas at least that there's some inconsistency on.
Well, again, I don't think anyone would argue that there's a need for safety and health regulations in the workplace across the board, that there's a need for a minimum standard with respect to Fair Labor Standards Act, that there are minimums, and the tribes and tribal leaders are looking at those and determining for themselves, no, that federal law works for us.
But-
we're going to enact it as tribal.
But then doesn't that make you pick and choose which laws? Because I understand you can have under your sovereignty, you can have labor laws. You've got unions in your facilities. You do not have unions in your facilities. Great example. But all these other things, you're now saying there's minimum standards, that's why you comply with them. But there's still a direct inconsistency with
Well-
some of these other laws. I mean, so I guess, you know, if we want to make it your sovereign or not, we should fix things across the board and not just pick on the labor relations. Because I understand, you know, Lieutenant Governor Keel, your argument was that if the blackjack dealers struck, it would be a, what was the exact term? It would cripple government operations. I might argue with that a bit. I think, you know, that may not cripple your government operations, but you're picking and choosing, this is the one law you want to fix on, but not all the other laws. You just said there's certain minimum standards you have to have for safety, therefore you're complying with OSHA, but really you probably shouldn't be under OSHA by the argument you're making today. So I'm just wondering how we come across the board and fix it, or why we're picking and choosing which ones we want to attack and which ones we don't want to attack, because I think it's kind of a holistic approach. You're sovereign or you're not, then we should really have everything included, or else we're really not doing our jobs.
Well, again, there's the limited nature of sovereignty with respect to the states themselves. They have chosen to limit their sovereignty, as the tribes have chosen to limit their sovereignty in their relationship with the United States. I just would stress the fact that the NLRA is fundamentally different with respect to what it provides and authorizes third parties coming onto Indian lands, organizing employees, the ability to interact in such ways that could interfere with political elections, and that's the concern that tribal leaders have brought to Congress, that concern. Not concern about safety standards, not concerns about wages and overtime, it's about unions coming onto reservations.
Gotcha, thank you.
Thank you, gentlemen, for yielding. Mr. Allen, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to our panelists for appearing here today. Get my microphone to get in front of me there. I think we all agree today that tribal sovereignty is a long-standing treaty between tribal nations and the United States, and you know, I will remind our colleagues today that we are talking about the NLRB infringing on the rights of Native Americans and our concern for that, and that is the subject of the day. We can take up the rest of these issues, and we'll be glad to offer bills to take up those issues when they apply. Today we're talking about labor. We need to ensure that Native Americans are protected from NLRB interference. And with that, Lieutenant Governor Keel, it is my understanding that Indian nations use the profits from the casinos to support tribal community and self-government. How are the profits from your casino used by the Chickasaw Nation?
Thank you, sir. The revenues that are derived from our casinos are used to meet the shortfall where the federal government does not provide services or enough funding for many of our services. These include elder care. Many of our senior nutrition sites are completely, totally tribally funded. We have youth camps, we have scholarships, education. We have a number of other services that are provided for our veterans and our health care, housing, emergency services, and other types of services that are provided to our citizens that are outside the purview of federal funding. We operate programs, for instance, for daycare for our employees, Head Start, and other types of assistance to our employees so that they can come to work and earn a living so that they can provide for their families.
How do your employee wages and benefits compare to, say, local averages? And have the unions attempted to unionize the Chickasaw Nation Casino?
Our benefits, our wages and benefits either meet or exceed, in most cases exceed the local averages anywhere in our area. We do comparisons to even the metropolitan areas of Dallas-Fort Worth, which is usually a higher standard than where we're located.
Better than Georgia.
It's
better than the state of Georgia.
Yeah. So our benefit packages are designed to at least meet or exceed, in most cases, any of those comparatively.
Have the unions attempted to unionize your casino?
At WinStar World Casino, yes, there was a situation where an individual disagreed with our Indian preference, and that led to some other issues.
And that's why it failed, do you think?
Yes.
Okay. I believe that some federal laws do apply to tribal lands, and what federal laws apply, is their application explicit in the law, and how has the Supreme Court determined whether federal laws apply in the event of ambiguity? Is there any mention of Indian tribes in either the NLRA or its legislative history? And anyone care to take that question?
No, there's the NLRA and its legislative history is absolutely silent with respect to Indian tribes.
Okay.
The Supreme Court has not yet addressed the issue other than through its Tuscarora ruling back in the 1960s that established that under the Federal Power Act, which had a provision specific to Indian lands, Indian tribes, and Indian individuals, it nonetheless still went back and answered an argument saying that federal laws of general application would apply to Indians. And from that decision, the lower courts have built up a framework that the NLRB now follows called the Tuscarora Coeur d'Alene framework. Not all the circuits are in agreement with that framework. The D.C. Circuit in San Manuel went another way. The Sixth Circuit appears to have adopted that framework. And other circuits, the 10th Circuit is still non-committal on that question. So the courts are all over the place with respect to what's the test. To sort of clarify, the rule that was established by the U.S. Supreme Court early in its Indian law jurisprudence basically said that unless Congress spoke specifically and applied a law to an Indian tribe, it would not apply. That is what's now been reversed. There was an understanding that if that law was going to impact tribal sovereignty, Congress had to be explicit that it intended that law to do just that, and Congress has.
Thank you. I yield back.
I thank the gentleman for yielding. Ms. Bonamici, you're recognized for 5 minutes.
Thank you very much, Mr. Chairman. And Mr. Chairman, you said at the beginning of the hearing that this was a clear issue, and with all due respect, I don't see it that way. I don't see it clear at all. It is clear that we all respect tribal sovereignty. I don't think there's a question about that. But I submit that there's also no question that tribal members and non-tribal members who work at tribal casinos deserve the protections and rights that are provided by the National Labor Relations Act. So we have, it's my understanding right now, 566 legally recognized tribes. And I know Chair Butler talked about the employees at Foxwood and how they were able to organize because your tribe has a labor relations law. And Mr. Guest, you mentioned in your testimony something about the Navajo Nation Labor Code. California has a tribal labor relations ordinance. Lieutenant Governor Keel didn't say whether the Chickasaw Nation has a tribal labor relations law that would allow workers to form a union. I do know there were troubles a few years ago when the employees tried to form a union. And to further complicate the issue, there are many employees who are not tribal members who work in casinos, and this issue tends to come up at tribal casinos. So Mr. Guest, in your testimony, you encouraged the committee to support this legislation because you said tribes should not be subject to a one-size-fits-all approach. But the NLRB's current test for invoking jurisdiction over tribal enterprises involves a case-by-case analysis that accounts for the different legal, political, and economic circumstances of each enterprise. And it looks like really there are differences among the 566 tribes, and so different tribal members have different protections. So the legislation simply eliminates the jurisdiction without considering any of the tribal diversity you cite. So isn't it fair to say that it's the bill that's the one-size-fits-all approach, and that the current jurisdictional consideration would analyze whether those protections are there for tribal members?
Thank you, Congresswoman. I can see how you and how others might misinterpret what my intended meaning was there. With respect to what it intends to address is no amendments to H.R. 511, which tries to impose additional restrictions on tribes because tribes are diverse. It wasn't intended to address the fact that H.R. 511, what it would do is allow each individual tribe to decide for itself what its labor policy is going to be on the reservation on Indian lands. I apologize for that confusion there.
And I'm going to go to Mr. Navaro. Thank you very much for your testimony. You mentioned that one of the things that motivated you to be part of an organizing effort at your casino was because you saw your colleagues face penalties for raising sexual harassment grievances. So tribal employees are exempt from the protections of Title VII, so as a result, employees who are subjected to forms of employment discrimination at tribally owned workplaces don't have any recourse. I read a story about a woman who worked at a swamp safari in Florida, and she filed a suit against her employer after he allegedly sexually harassed her, and the court dismissed her case because of sovereign immunity. So, Mr. Navaro, how does your membership in a union help you and your coworkers address things like harassment and employment discrimination issues? What difference does that make?
It gives us protection from everything, like, example, from this harassment cases that happened. We had members from Stations Casino who represents Great and Rancheria tribe, and I would like to thank them also for letting me be here today because they have been very supportive of our union. They've been absolutely wonderful. They let us go ahead and negotiate at the casino with them there. And but this actually helps us because these women, literally, I witnessed this. I watched the manager who was running this department would go up to them and tell them, if you want to raise, let's go and have sex at my house. Or he would text them and tell them, hey, let's go to my house. We're going to have a party. The game's on. Let's get in the pool afterwards. And when we took it up with our management, which was Stations, we were told that it was a sovereign nation and that they would deal with it, how they would diligent how they would do it. And we sat back and watched these girls the next day get escorted out by security because they were fired for all the allegations they made. And it wasn't until Chairman Saris stepped up and said, hey, you guys need to step back, and do diligently on when you fire people. And he said, you guys need to let them go ahead and organize their casino. It helped us because we finally had a voice, and those women that were fired, I felt like they got some kind of repercussion out of it because we were getting the chance to stand and have a voice. Unfortunately, they're no longer there. A couple months after Chairman Saris came in, the supervisor was removed from Stations Casino and moved to another casino in Minnesota.
Thank you very much for being here in your testimony, and my time has expired. I yield back. Thank you.
Thank the gentlelady for yielding. Mr. Spokane?
Yeah, thank you, Mr. Chairman. I just have 5 letters I would like to ask unanimous consent to have entered into the record.
Without objection, so ordered.
Thank
Mr. Grothman, you are recognized for 5 minutes.
Okay, couple questions. First question, just in general, and we've covered this before. I think the appropriate parallel is not any other business, but local units of government. Because if I had to say, traditionally, I think when we pass laws around here, we exempt state governments or exempt local units of government. How does it make you feel that compared to other locals of government, you seem to be treated less important or less capable of self-governance?
Congressman, we've been dealing with that for centuries, right? And it's unfortunate. And going back to Congressman Pocane's point, excellent point about why aren't we addressing all these at one time? There's a lot of issues that as in the Indian country we would want to address at one time, right? And whether it's tax parity, whether it's, again, the bankruptcy code that I mentioned earlier, whether it's fair access to health care. And there's so many things that we would absolutely want to address at one time and would have liked to have addressed 150 years ago, but that's just not the way the legislative process works. And so clearly, we felt like we've been dealt an unfair hand, and as these issues come up and the opportunities to address them, we want to address them.
Okay. Under San Manuel, the board will not assert jurisdiction if the application of the law would abrogate treaty rights. Under this standard, who determines whether the application of the law would abrogate treaty rights? Does the board have any special knowledge of Indian or treaty law? And what level of deference should the courts give this determination by the board?
Well, Mr. Grotham, the NLRB itself admits in the Chickasaw decision that it has no expertise in this area. The Sixth Circuit, in its decision in the Little River Band case, says, NLRB, you have no expertise in this area, so no Chevron deference for you. I mean, there's no question by the NLRB or anyone else that they have no expertise in Indian affairs, and yet they are calling upon themselves to interpret treaties, to determine what interferes with affairs on the reservation with the tribe, that they simply have no expertise in whatsoever.
Thanks. Did the NLRB engage with the public prior to deciding this? Did they request briefs, for example?
Yes, they followed their administrative process through the proceedings. Yes, sir.
Okay, I'll yield the rest of my time.
Thank you, gentlemen, for yielding. Mr. Akita, you're recognized for 5 minutes.
I thank the chairman not only for the time as not a member of the subcommittee, but for your leadership in bringing this bill forward. It's, as you can tell, it's greatly appreciated. I also thank Chairman Klein for his leadership in getting this bill to the stage it is in today. I thank all the witnesses for your testimony. I think it's been very enlightening and very helpful to many of us who are honestly trying to learn more about this situation and get to an equitable and proper resolution. I am a little concerned, if not dismayed, about some of my colleagues who want to get themselves wrapped around the axle about why the NLRB and not the OSHA and not some of these other things. And I'd simply like to remind them of the title of today's hearing, Legislative Hearing on H.R. 5, Tribal Labor and Sovereignty Act of 2015. Now, this bill is certainly not my idea. I am carrying, and I love the idea. It's been around for quite a while now, but it focuses on the NLRB. Who knows? Maybe tomorrow, Lieutenant Governor, I'll file a bill on OSHA or something else. But I want to have Mr. Guest reiterate his what I believe to be 2 points here about the differences. First of all, this is a bill about parity. If the tribal communities have a government, why shouldn't it be treated just like the other governments in these United States, whether it be federal, state, or local level? And the second issue has to do with this third party you talk about, because I think that is also very important. OSHA doesn't invite third parties into a situation and take away the rights of an otherwise sovereign nation. NLRB does, and in fact is trying to do that. Mr. Guest, can you reiterate for the record these 2 points, just so we're crystal clear? Parity and third parties.
Yes, thank you, Mr. Okita. And I think that it clearly demonstrates in terms of IGRA itself, the Indian Gaming Regulatory Act, where Congress spoke, and Congress spoke about tribal gaming as a governmental activity, that Congress itself says that gaming revenues are to be used for these limited purposes, specifically for supporting tribal programs and services, and not for anything else. When we were at the Sixth Circuit in the Little River Band case, one of the judges said, well, aren't those Indian casinos just like every other casino? Don't those Indians just stick that money in their pocket? I mean, this is the challenge we have in the courts today with respect to a lack of real clarity on why it is that these are tribal governmental employees working at a casino. And so when we come in and we say, you need to treat them the same, you need to treat tribes the same as all other governments, as state and local governments, as the federal government, it's difficult for others to see it because they say, well, that's just like any other commercial enterprise, isn't it? And it's like, no, it's not. It's a governmental enterprise that generates revenues because tribes don't have solid tax bases the way state and local governments may. And so there is no other source for revenues, and why the concern with the NLRA applying on reservation and allowing strikes to occur, which can cripple tribal government. That's where the concern
And in
comes
fact,
from.
not in parity with other governments.
Right.
Correct.
Exactly.
Okay. Thank you, Mr. Guest. Now, I've also was concerned about some of the questions being asked regarding, and I think it was driven by some of Mr. Navaro's testimony, regarding crimes or other occurrences on reservations. And I want to give Chairman Butler and Lieutenant Governor Keel a chance to clear these things up. So I'm going to ask questions I want both of you to answer, okay? Do you have, as government leaders, an interest in keeping your government workers safe?
Absolutely.
Yes.
Absolutely.
Absolutely.
All right. Do you, in fact, have laws regarding this?
Absolutely.
As a sovereign nation? Yes. You both answered yes.
Yes.
Do you know of any tribal community that doesn't address this issue?
No.
No.
Okay. Second question. Do you tolerate sexual assault or any other kind of misconduct in any of your enterprises?
Not at all.
No.
Do you
Not
have,
at all.
both have answered no to that question. Do you have laws regarding this kind of conduct? Criminal or otherwise?
Yes.
Regarding sexual assault or any
Yeah,
other
we
kind
have
of
laws,
assault on
absolutely.
a worker, right?
Yes.
Do you know of any tribal community that doesn't?
No.
Right. Final question. Do you mistreat enrolled members who happen to have disabilities?
Not at all.
Okay.
We actually have special programs for them.
Mr. Butler says no and has special programs for him. Lieutenant Governor?
We have special programs for all of our people.
Right, I think that. And do you know of any tribe, final question, do you know of any tribe that mistreats their members who have disabilities?
No.
And
No.
you take care of your own?
Absolutely.
Mr. Chairman, I yield back.
The gentleman's time has expired. I would like to take this time again to thank each and every one of you for taking your time in preparation and testifying before the subcommittee today. I think all of you made excellent witnesses, and I appreciate you being here. I know you spent a lot of time and effort to get here, so thank you for doing that. I'll now recognize my colleague, Mr. Polis, for his closing remarks.
Well, I want to thank everyone for your impassioned and honest testimony and answers. I truly hope that everyone on our committee will analyze this issue objectively and try to take the effort to understand what's been said here. And as we consider this issue, it's very important to keep in mind the nexus between balancing our domestic sovereign nation's rights with the protections that are due to all American workers, regardless of whether they're white, black, Hispanic, or Native American. Without the right to self-governance, including additional rights that have often been afforded through treaty, we wouldn't have the strong Native American communities and nations that are present across our country today. But so too, without the right to collectively bargain, we would not have the strong and growing economy that offers a pathway to the middle class for so many American families. I look forward to continuing this discussion with individuals and experts on both sides of the issue as we seek to reconcile these two principles that many of us on this committee hold dear. And I yield back the balance of my time.
Thank you, gentlemen, for yielding, and I again thank the excellent committee we've had here, the witnesses we've had, and I want to just finish by saying this, to me, is fairly clear and fairly simple. You either are a sovereign nation or you're not. That's pretty simple. And I don't know whether we can go to the British Embassy, which is sovereign property here, and require them to do these things. I don't think you can. So the National Labor Relations Act very specifically says the NLRA does not cover all employees and employers in the United States. For example, public sector employees, state, local, and federal, and employers covered by the Railway Labor Act, airlines and railroads, agriculture labor, and supervisors are not covered by the act. Basically, what you're doing is to clarify this, that a sovereign Native American nation also is not covered by this act. And we're not talking about the other things that were brought up, all very, very valid things, but you should be able to make your own decisions on your own land. We have a 10th Amendment in the United States Constitution, which we've been fighting about who has the power in this government, whether the state does, and I'm always going to lean on, I'm a former mayor. I'm always lean on the best government you have is local government. The further it gets from you, the worse and least responsive it is for you. So I think this is very simple. I would urge support and full disclosure. I'm a co-sponsor of this bill. And once again, I appreciate each one of you coming. And with no further business, the subcommittee stands adjourned.
Thank you.
Thank you, Chairman, Committee.
see you.
Absolutely. Oh, yeah, Gary.
All right, thank you, man. Very nice to meet you. Thank you.
Safe travels.
Oh, yeah, thank you.
Well, you're stopping at the reunion first, right?
Yeah, I'm going back.
In the overflow room, looking over the shoulder, I could keep see Wolf looking at the camera.
Thank you so much. Thank you so much. Thank you. Thank you.